The real purpose of law reporting is to record decisions of courts, and in its extended format to include laws that have been passed by Parliament. Laws don't take effect unless they are published. So publication is important for that law to have effect. Secondly, an individual can challenge the effectiveness of a law that has not been published in its proper format. What this does is to bring what are popularly known as the government gazettes into play. From our own experiences, we know that you rarely see the government gazette unless you go to some specialized library or if you're in a well-resourced law firm that actually subscribes to it. Publication plays a central role in bringing legal effect. Law reporting plays a greater role because this is how you hold your government to account. You want to know the laws that have been passed. You want to know the decisions that have been made so that you can challenge them. With regards to judicial decisions, you want to know what the judges have decided. We have an open justice principle, which basically means that all courts must sit in the open, and the decision making is made in an open fashion. The principle of open justice is what prevents a lot of our judiciaries falling into the dangers of corruption. Why do we bother ourselves about having these decisions out there? The general position is that the most important person in a court hearing is the one who loses. This is the person who has to read it and understand why they lost. And it is very important for that person to be convinced that the judicial officer heard that person's case, heard mine, applied the law in the way they were supposed to, and arrived at this decision. Once you find that the person against whom the decision is gone cannot understand why the judges arrived at this decision, you have a problem. That, in a nutshell, is the philosophy behind the openness with legal information. It plays a critical role in the establishment of our democracies. So, law reporting is part of the effort that we are putting out there to inform citizens that the right that they have given to the state to perform this particular duty is not being abused. Law reporting sits central to a democracy. This is why law reporting is not popular. It is because it brings out accountability. That is why the state of law reporting in Africa is not enviable. It is difficult to find law reports in many of our countries. We have backlogs stretching back many years. You start to ask the judge, why did you arrive at this decision when the law says etc.? Why is Parliament passing this law when it is against this particular right? There are people who have power who are going to resist the efforts you are going to put in. Moving from a culture when somebody does anything that they so wish to a culture where you say everything that you do must be justified. So the state of law reporting in Africa, you will find, is affected by the secrecy mentality. And to get past it is a big war. The judges are given bigger cars. They've driven in at 7 this morning. They'll leave at 5. They are in that car only 20 minutes, 30 minutes a day. And it's worth 100,000. But they go to offices without paper, without computers. They don't get adequate training. They don't get the basic textbooks. The interest of the state is more now in establishing this status. But the member of the public is not actually getting the justice that they want. We have also the challenge of diverse systems of law. In some of the African countries that are French-speaking, precedent doesn't play a greater role. In the common law jurisdictions, we are able to predict what the result is going to be. But also it has its challenges because sometimes we have difficulties adjusting to new realities. There are changes that are happening, and yet our systems are not adapting to them. We have a Commonwealth format that we have all inherited. If it's the Constitutional Court of South Africa, you rarely find a judgment under 30 pages. There are some that go up to several hundreds. I think the longest about 400. The format that we have adopted makes it more difficult to get these judgments out because this guy has to spend 30 days sitting to write 50 pages. Because if he does it in 5, he is not considered to have been learned. But does it serve a purpose? Because he's going to delay it for a year when this judge is struggling through 50 law reports, when in fact he probably just needs to cite 5 decisions and then give you a result in a week. We also have reliance on foreign sources. That is causing a challenge. A lot of the laws, decisions of our courts are not developing the law. They are simply restating positions that have taken place in other countries. And the level of sharing that we have within the region is very poor. We only see now with the emergence of SAFLI and the access to information that we have now online that judges are beginning to cite decisions from Uganda, from Botswana, from Namibia. But it was easier to get a Canadian, Australian or UK source, despite the fact that the socio-economic situation is totally different. Then we have the challenges of IT. We now need to make sure that the processes that we have in courts adjust to that, but they are still paper-based, writing in longhand, unable to type. You can't communicate with many of our judges even by email. There are many law schools in our region that are still accepting assignments in handwritten form. So that's a problem, because you are trying to pull everyone in the IT way, which is cheaper, quicker, and the like. But the law students that you are producing are actually not adapted to it. And these are the guys who are going to come in and practice in this course. These are the guys who are going to become your judges. We have judges that have been judges for 30 years, and all they have are judgments that they've passed in the last 3 years in electronic form. So a lot of the work that they have done has been lost. So it has affected also our ability to report on the law and our ability to keep records.